Hello again, everyone. Welcome back to Matt Reads Books. You might remember that we're going through A Theory of Justice by John Rawls today, or we have been at least. So let me set up our timer, and we're going to do another 30-ish minutes of that. Okay, 3, 2, 1. Here we go, John Rawls. Part 4, Section 4, the original position and justification. I have said that the original position is the appropriate initial status quo which ensures that the fundamental agreements reached in it are fair. This fact yields the name justice's fairness. It is clear, then, that I want to say that one conception of justice is more reasonable than another, or justifiable with respect to it, if rational persons in the initial situation would choose its principles over those of the other for the role of justice. Conceptions of justice are to be ranked by their acceptability to persons so circumstanced. Understood in this way, the question of justification is settled by working out a problem of deliberation. We have to ascertain which principles it would be rational to adopt given the contractual situation. This connects the theory of justice with the theory of rational choice. If this view of the problem of justification is to succeed, we must, of course, describe in some detail the nature of this choice problem. A problem of rational decision has a definite answer only if we know the beliefs and interests of the parties, their relations with respect to one another, the alternatives between which they are to choose, the procedure whereby they make up their minds, and so on. As the circumstances are presented in different ways, correspondingly different principles are accepted. The concept of the original position, as I shall refer to it, is that of the most philosophically favored interpretation of this initial choice situation for the purposes of a theory of justice. But how are we to decide what is the most favored interpretation? I assume, for one thing, that there is a broad measure of agreement that principles of justice should be chosen under certain conditions. To justify a particular description of the initial situation, one shows that it incorporates these commonly shared presumptions. One argues from widely accepted but weak premises to more specific conclusions. Each of the presumptions should by itself be natural and plausible. Some of them may seem innocuous or even trivial. The aim of the contract approach is to establish that, taken together, they impose significant bounds on acceptable principles of justice. The ideal outcome would be that these conditions determine a unique set of principles. But I shall be satisfied if they suffice to rank the main traditional conceptions of social justice. One should not be misled, then, by the somewhat unusual conditions which characterize the original position. The idea here is simply to make vivid to ourselves the restrictions that it seems reasonable to impose on arguments for principles of justice, and therefore on these principles themselves. Thus it seems reasonable and generally acceptable that no one should be advantaged or disadvantaged by natural fortune or social circumstances in the choice of principles. It also seems widely agreed that it should be impossible to tailor principles to the circumstances of one's own case. We should ensure, further, that particular inclinations and aspirations and persons' conceptions of their good do not affect the principles adopted. The aim is to rule out those principles that it would be rational to propose for acceptance, however little the chance of success, only if one knew certain things that are irrelevant from the standpoint of justice. For example, if a man knew that he was wealthy, he might find it rational to advance the principle that various taxes for welfare measures be counted unjust. If he knew that he was poor, he would most likely propose the contrary principle. To represent the desired restrictions, one imagines a situation in which everyone is deprived of this sort of information. One excludes the knowledge of those contingencies which sets men at odds and allows them to be guided by their prejudices. In this manner, the veil of ignorance is arrived at in a natural way. This concept should cause no difficulty if we keep in mind the constraints on arguments that it is meant to express. At any time we can enter the original position, so to speak, simply by following a certain procedure, namely, by arguing for principles of justice in accordance with these restrictions. It seems reasonable to suppose that the parties in the original position are equal. That is, all have the same rights in the procedure for choosing principles. Each can make proposals, submit reasons for their acceptance, and so on. Obviously, the purpose of these conditions is to represent equality between human beings as moral persons, as creatures having a conception of their good and capable of a sense of justice. The basis of equality is taken to be similarity in these two respects. Systems of ends are not ranked in value, and each man is presumed to have the requisite ability to understand and to act upon whatever principles are adopted. Together with the veil of ignorance, these conditions define the principles of justice as those which rational persons, concerned to advance their interests, would consent to as individuals when none are known to be advantaged or disadvantaged by social and natural contingencies. There is, however, another side to justifying a particular description of the original position. This is to see if the principles which would be chosen match our considered convictions of justice or extend them in an acceptable way. We can note whether applying these principles would lead us to make the same judgments about the basic structure of society, which we now make intuitively and in which we have the greatest confidence, or whether, in cases where our present judgments are in doubt and given with hesitation, these principles offer resolution which we can affirm on reflection. There are questions which we feel sure must be answered in a certain way. For example, we are confident that religious intolerance and racial discrimination are unjust. We think that we have examined these things with care and have reached what we believe is an impartial judgment not likely to be distorted by an excessive attention to our own interests. These convictions are provisional fixed points, which we presume any conception of justice must fit. But we have much less assurance as to what is the correct distribution of wealth and authority. Here we may be looking for a way to remove our doubts. We can check an interpretation of the initial situation then by the capacity of its principles to accommodate our firmest convictions and to provide guidance where guidance is needed. In searching for the most favored description of this situation, we work from both ends. We begin by describing it so that it represents generally shared and preferably weak conditions. We then see if these conditions are strong enough to yield a significant set of principles. If not, we look for further premises equally reasonable. But if so, and these principles match our considered convictions of justice, then so far well and good. But presumably there will be discrepancies. In this case, we have a choice. We can either modify the account of the initial situation, or we can revise our existing judgments. For even the judgments we take provisionally as fixed points are liable to revision. By going back and forth, sometimes altering the conditions of the contractual circumstances, at others withdrawing our judgments and conforming them to principle, I assume that eventually we shall find a description of the initial situation that both expresses reasonable conditions and yields principles which match our considered judgments, duly pruned and adjusted. This state of affairs I refer to as a reflective equilibrium. This is sort of a key term for Rawls. It is an equilibrium because, at last, our principles and judgments coincide. And it is reflective since we know to what principles our judgments conform and the premises of their derivation. At the moment, everything is in order. But this equilibrium is not necessarily stable. It is liable to be upset by further examination of the conditions which should be imposed on the contractual situation, and by particular cases which may lead us to revise our judgments. Yet, for the time being, we have done what we can to render coherent and to justify our convictions of social justice. We have reached a conception of the original position. I shall not, of course, actually work through this process. Still, we may think of the interpretation of the original position that I shall present as the result of such a hypothetical course of reflection. It represents the attempt to accommodate within one scheme both reasonable philosophical conditions on principles as well as our considered judgments of justice. In arriving at the favored interpretation of the initial situation, there is no point at which an appeal is made to self-evidence in the traditional sense, either of general conceptions or particular convictions. I do not claim for the principles of justice proposed that they are necessary truths or derivable from such truths. A conception of justice cannot be deduced from self-evident premises or conditions on principles. Instead, its justification is a matter of the mutual support of many considerations, of everything fitting together into one coherent view. A final comment. We shall want to say that certain principles of justice are justified because they would be agreed to in an initial situation of equality. I have emphasized that this original position is purely hypothetical. It is natural to ask why, if this agreement is never actually entered into, we should take any interest in those principles, moral or otherwise. The answer is that the conditions embodied in the description of the original positions, in the description of the original position, are ones that we do in fact accept. Or, if we do not, then perhaps we can be persuaded to do so by philosophical reflection. Each aspect of the contractual situation can be given supporting grounds. Thus, what we shall do is to collect together into one conception a number of conditions on principles that we are ready upon due consideration to recognize as reasonable. These constraints express what we are prepared to regard as limits on fair terms of social cooperation. One way to look at the idea of the original position, therefore, is to see it as an expository device which sums up the meaning of these conditions and helps us to extract their consequences. On the other hand, this conception is also an intuitive notion that suggests its own elaboration, so that led on by it, we are drawn to define more clearly the standpoint from which we can best interpret moral relationships. We need a conception that enables us to envision our objective from afar. The intuitive notion of the original position is to do this for us. Section 5. Classical Utilitarianism. There are many forms of utilitarianism, and the development of the theory has continued in recent years, with recent, of course, being 1971, but then revised in 1991. And of course, utilitarianism is still very much alive. The development of the theory has continued in recent years. I shall not survey these forms here, nor take account of the numerous refinements found in contemporary discussions. My aim is to work out a theory of justice that represents an alternative to utilitarian thought generally, and so to all of these different versions of it. I believe that the contrast between the contract view and utilitarianism remains essentially the same in all these cases. Therefore, I shall compare justice's fairness with familiar variants of intuitionism, perfectionism, and utilitarianism in order to bring out the underlying differences in the simplest way. With this end in mind, the kind of utilitarianism I shall describe here is the strict classical doctrine which receives perhaps its clearest and most accessible formulation in Sidgwick. The main idea is that society is rightly ordered, and therefore just, when its major institutions are arranged so as to achieve the greatest net balance of satisfaction summed over all the individuals belonging to it. We may note first that there is indeed, and then there's a footnote to Sedgwick's The Methods of Ethics, the 7th edition, from 1907, and Book 3 of his Principles of Political Economy, and Pigue's The Economics of Welfare, Sidgwick's Outline of the History of Ethics, etc., Shaftesbury, Hutchinson, Hume, of course, Smith, Bentham, Mill, and Edgeworth. And then more contemporary authors, Herod's Utilitarianism Revised, etc., 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 etc. Yes, these are, it's just a nice bibliography of utilitarian thinkers through the ages in footnote 9 on page 20 of the edition that I have. We may note that there is, indeed, a way of thinking of society which makes it easy to suppose that the most rational conception of justice is utilitarian. For consider, each man, in realizing his own interests, is certainly free to balance his own losses against his own gains. We may impose a sacrifice on ourselves now for the sake of a greater advantage. A person quite properly acts, at least when others are not affected, to achieve his own greatest good, to advance his rational ends as far as possible. Now, why should not a society act on precisely the same principle, applied to the group, and therefore regard that which is rational for one man as right for an association of men? Just as the one being of a person is constructed from the series of satisfactions that are experienced at different moments in the course of his life, so in very much the same way, the well-being of society is to be constructed from the fulfillment of the systems of desires of the many individuals who belong to it. Since the principle for an individual is to advance as far as possible his own welfare, his own system of desires, the principle for society is to advance as far as possible the welfare of the group, to realize to the greatest extent the comprehensive system of desire arrived at from the desires of its members. Just as an individual balances present and future gains against present and future losses, so a society may balance satisfactions and dissatisfactions between different individuals. And so, by these reflections, one reaches the principle of utility in a natural way. Society is properly arranged when its institutions maximize the net balance of satisfaction. The principle of choice for an association of men is interpreted as an extension of the principle of choice for one man. Social justice is the principle of rational prudence, applied to an aggregate conception of the welfare of the group. See section 30. The idea is made all the more attractive by a further consideration. The two main concepts of ethics are those of the right and the good. The concept of a morally worthy person is, I believe, derived from them. The structure of an ethical theory is, then, largely determined by how it defines and connects these two basic notions. Now, it seems that the simplest way of relating them is taken by teleological theories. The good is defined independently from the right, and the right is defined as that which maximizes the good. More precisely, those institutions and acts are right which, of the available alternatives, produce the most good, or at least as much good as any of the other institutions and acts open as real possibilities. At least as much as the alternatives, basically. A rider needed when the maximal class is not a singleton. Teleological theories have a deep intuitive appeal, since they seem to embody the idea of rationality. It is natural to think that rationality is maximizing. And it's maximizing something, and that in morals, it must be maximizing the good. Indeed, it is tempting to suppose that it is self-evident that things should be arranged so as to lead to the most good. It is essential to keep in mind that in teleological theory, the good is defined independently from the right. This means two things. First, the theory accounts for our considered judgments as to which things are good, as a separate class of judgments intuitively distinguishable by common sense, and then proposes the hypothesis that the right is maximizing the good as already specified. Second, the theory enables one to judge the goodness of things without referring to what is right. For example, if pleasure is said to be the sole good, then, presumably, pleasures can be recognized and ranked in value by criteria that do not presuppose any standards of right, or what we would normally think of as such. Whereas, if the distribution of goods is also counted as a good, perhaps a higher order one, and the theory directs us to produce the most good, including the good of distribution, among others, we no longer have a teleological view in the classical sense. The problem of distribution falls under the concept of right, as one intuitively understands it, and so the theory lacks an independent definition of the good. The clarity and simplicity of classical teleological theories derives largely from the fact that they factor our moral judgments into two classes, the one being characterized separately, while the other is then connected with it by a maximizing principle. Teleological doctrines differ pretty clearly according to how the conception of the good is specified. If it is taken as the realization of human excellence in the various forms of culture, as we have what may be called perfectionism. This notion is found in Aristotle and Nietzsche, among others. If the good is defined as pleasure, we have hedonism. If as happiness, eudaimonism, and so on. I shall understand the principle of utility in its classical form as defining the good as the satisfaction of desire, or perhaps better, the satisfaction of rational desire. This accords with the view in all essentials and provides, I believe, a fair interpretation of it. The appropriate terms of social cooperation are settled by whatever in the circumstances will achieve the greatest sum of satisfaction or the rational desires of individuals. It is impossible to deny the initial plausibility and attractiveness of this conception. The striking feature of the utilitarian view of justice is that it does not matter, except indirectly, how this sum of satisfactions is distributed among individuals any more than it matters, except indirectly, how one man distributes his satisfactions over time. The correct distribution in either case is that which yields the maximum fulfillment. Society must allocate its means of satisfaction, whatever these are, rights and duties, opportunities and privileges, and various forms of wealth, so as to achieve this maximum if it can. But in itself, no distribution of satisfaction is better than another, except that the more equal distribution is to be preferred to break ties. It is true that certain common sense precepts of justice, particularly those which concern the protection of liberties and rights, or which express the claims of desert, seem to contradict this contention. But from a utilitarian standpoint, the explanation of these precepts and of their seemingly stringent character is that they are those precepts which experience shows should be strictly respected and departed from only under exceptional circumstances if the sum of advantages is to be maximized. See Mill's Utilitarianism. Yet, as with all other precepts, those of justice are derivative from the one end of attaining the greatest balance of satisfaction. Thus, there is no reason in principle why the greater gains of some should not compensate for the lesser losses of others. Or, more importantly, why the violation of the liberty of a few might not be made right by the greater good shared by many. It simply happens that under most conditions, at least in a reasonably advanced stage of civilization, the greatest sum of advantages is not attained in this way. No doubt, the strictness of common sense precepts of justice has a certain usefulness in limiting men's propensities to injustice and to socially injurious actions. But the utilitarian believes that to affirm this strictness as a first principle of morals is a mistake. For just as it is rational for one man to maximize the fulfillment of his system of desires, it is right for society to maximize the net balance of satisfaction taken over all of its members. The most natural way, then, of arriving at utilitarianism, although not, of course, the only way of doing so, is to adopt for society as a whole the principle of rational choice for one man. Once this is recognized, the place of the impartial spectator and the emphasis on sympathy in the history of utilitarian thought is readily understood. For it is by the conception of the impartial spectator and the use of sympathetic identification in guiding our imagination that the principle for one man is applied to society. It is this spectator who is conceived as carrying out the required organization of the desires of all persons into one coherent system of desire. It is by this construction that many persons are fused into one. Endowed with ideal powers of sympathy and imagination, the impartial spectator is the perfectly rational individual who identifies with and experiences the desires of others as if these desires were his own. In this way, he ascertains the intensity of these desires and assigns them their appropriate weight in the one system of desire and satisfaction of which the ideal legislator then tries to maximize by adjusting the rules of the social system. On this conception of society, separate individuals are thought of as so many different lines along which rights and duties are to be assigned, and scarce means of satisfaction allocated in accordance with rules, so as to give the greatest fulfillment of wants. The nature of the decision made by the ideal legislator is not, therefore, materially different from that of an entrepreneur deciding how to maximize his profit by producing this or that commodity, or that of a consumer deciding how to maximize his satisfaction by the purchase of this or that collection of goods. In each case, there is a single person, His system of desires determines the best allocation of limited means. The correct decision is essentially a question of efficient administration. This view of social cooperation is the consequence of extending to society the principle of choice for one man, and then, to make his extension work, conflating all persons into one through the imaginative acts of the impartial, sympathetic spectator. Utilitarianism does not take seriously the distinction between persons. Section 6. Some related contrasts. It has seemed to many philosophers, and it appears to be supported by the convictions of common sense, that we distinguish as a matter of principle between the claims of liberty and right on the one hand, and the desirability of increasing aggregate social welfare on the other, and that we give a certain priority, if not absolute weight, to the former. Each member of society is thought to have an inviolability founded on justice, or, as some say, on natural right, which even the welfare of everyone else cannot override. Justice denies that the loss of freedom for some is made right by a greater good shared by others. The reasoning, which balances the gains and losses of different persons as if they were one person, is excluded. Therefore, in a just society, the basic liberties are taken for granted, and the rights secured by justice are not subject to political bargaining or to the calculus of social interests. Justice's fairness attempts to account for these common sense convictions concerning the priority of justice by showing that they are the consequence of principles which would be chosen in the original position. These judgments reflect the rational preferences and the initial equality of the contracting parties. Although the utilitarian recognizes that, strictly speaking, his doctrine conflicts with these sentiments of justice, he maintains that common sense precepts of justice and notions of natural right have but a subordinate validity as secondary rules. They arise from the fact that under the conditions of civilized society there is great social utility in following them for the most part and in permitting violations only under exceptional circumstances. Even the excessive zeal with which we are apt to affirm these precepts and to appeal to their rights is itself granted a certain usefulness, since it counterbalances a natural human tendency to violate them in ways not sanctioned by utility. Once we understand this, the apparent disparity between the utilitarian principle and the strength of these persuasions of justice is no longer a philosophical difficulty. Thus, while the contract doctrine accepts our convictions about the priority of justice as on the whole sound, utilitarianism seeks to account for them as a socially useful illusion. A second contrast is that whereas the utilitarian extends to society the principle of choice for one man, justice's fairness, being a contract view, assumes that the principles of social choice, and so the principles of justice, are themselves the object of an original agreement. There is no reason to suppose that the principles which should regulate an association of men is simply an extension of the principle of choice for one man. On the contrary, if we assume that the correct regulative principle for anything depends on the nature of that thing, and that the plurality of distinct persons with separate systems of ends is an essential feature of human societies, we should not expect the principles of social choice to be utilitarian. To be sure, it has not been shown by anything said so far that the parties in the original position would not choose the principle of utility to define the terms of social cooperation. This is a difficult question which I shall examine later on. It is perfectly possible, from all that one knows at this point, that some form of the principle of utility would be adopted, and therefore the contract theory leads eventually to a deeper and more roundabout justification of utilitarianism. In fact, a derivation of this kind is sometimes suggested by Bentham and Edgeworth, although it is not developed by them in any systematic way, and to my knowledge, it is not found in Sidgwick. For the present, I shall simply assume that the persons in the original position would reject the utility principle, and that they would adopt instead, for the kinds of reasons previously sketched, the two principles of justice already mentioned. In any case, from the standpoint of contract theory, one cannot arrive at a principle of social choice merely by extending the principle of rational prudence to the system of desires constructed by the impartial spectator. To do this is not to take seriously the plurality and distinctiveness of individuals, nor to recognize as the basis of justice that to which men would consent. Here we may note a curious anomaly. It is customary to think of utilitarianism as individualistic, and certainly there are good reasons for this. The utilitarians were strong defenders of liberty and freedom of thought, and they held that the good of society is constituted by the advantages enjoyed by individuals. Yet utilitarianism is not individualistic, at least when arrived at by the more natural course of reflection. Oh, okay, well, we'll go to the end of this section, which actually is quite a while. It's not individualistic, at least when arrived at by the more natural course of reflection, in that, by conflating all systems of desires, it applies to society the principle of choice for one man, and thus we see that the second contrast is related to the first, since it is this conflation and the principle based upon it which subjects the rights secured by justice to the calculus of social interests. The last contrast which I shall mention now is that utilitarianism is a teleological theory, whereas justice as fairness is not. By definition, then, the latter is a deontological theory, one that either does not specify the good independently from the right, or does not interpret the right as maximizing the good. It should be noted that deontological theories are defined as non-teleological ones, not as views that characterize the rightness of institutions and acts independently from their consequences. All ethical theories worth our attention take consequences into account in judging rightness. One which did not would simply be irrational, crazy. Rawls' words, not mine. I mean, but maybe that's right. Justice as fairness is a deontological theory in the second way, for it is assumed that the persons in the original position would choose a principle of equal liberty and restrict economic and social inequalities to those in everyone's interests. There is no reason to think that just institutions will maximize the good. Here I suppose with utilitarianism that the good is defined as a satisfaction of rational desire. Of course, it is not impossible that the most good is produced, but it would be a coincidence. The question of attaining the greatest net balance of satisfaction never arises in justice as fairness. This maximum principle is not used at all. There is a further point in this connection. In utilitarianism, the satisfaction of any desire has some value in itself, which must be taken into account in deciding what is right. In calculating the greatest balance of satisfaction, it does not matter, except indirectly, what the desires are for. We are to arrange institutions so as to obtain the greatest sum of satisfactions. We ask no questions about their source or quality, but only how their satisfaction would affect the total of well-being. Social welfare depends directly and solely upon the levels of satisfaction or dissatisfaction of individuals. Thus, if men take a certain pleasure in discriminating against one another, in subjecting others to a lesser liberty as a means of enhancing their self-respect, and the satisfaction of these desires must be weighed in our deliberations according to their intensity, or whatever, along with other desires, if society... then the satisfaction of these desires must be weighed in our deliberations according to their intensity, or whatever, along with other desires. If society decides to deny them fulfillment, or to suppress them, it is because they tend to be socially destructive, and a greater welfare can be achieved in other ways. In justice as fairness, on the other hand, persons accept in advance a principle of equal liberty, and they do this without a knowledge of their more particular ends. They implicitly agree, therefore, to conform their conceptions of the good to what the principles of justice require, or at least not to press claims which directly violate them. An individual who finds that he enjoys seeing others in positions of lesser liberty understands that he has no claim whatever to this enjoyment. The pleasure he takes in others' deprivations is wrong in itself. It is a satisfaction which requires the violation of a principle to which he would agree in the original position. The principles of right and of justice put limits on which satisfactions have value. They impose restrictions on what are reasonable conceptions of one's good. In drawing up plans and in deciding on aspirations, men are to take these constraints into account. Hence, in justice as fairness, one does not take men's propensities and inclinations as given, whatever they are, and then seek the best way to fulfill them. Rather, their desires and aspirations are restricted from the outset by the principles of justice which specify the boundaries that men's systems of ends must respect. We can express this by saying that in justice as fairness, the concept of right is prior to that of the good. A just social system defines the scope within which individuals must develop their aims, and it provides a framework of rights and opportunities and the means of satisfaction within and by the use of which these ends may be equitably pursued. The priority of justice is accounted for in part by holding that the interests requiring the violation of justice have no value. Having no merit in the first place, they cannot override its claims. And then he cites Kant in Critique of Practical Reason, Chapter 2, Book 1 of Part 1. And also a statement from Theory and Practice in Political Writings. This priority of the right over the good and justice as fairness turns out to be a central feature of the conception. It imposes certain criteria on the design of the basic structure as a whole. These arrangements must not tend to generate propensities and attitudes contrary to the two principles of justice, that is, to certain principles which are given from the first a definite content. And they must ensure that just institutions are stable. Thus, certain initial bounds are placed upon what is good and what forms of character are morally worthy, and so upon what kinds of persons men should be. Now, any theory of justice will set up some limits of this kind, namely, those that are required if its first principles are to be satisfied given the circumstances. Utilitarianism excludes those desires and propensities which, if encouraged or permitted, would, in view of the situation, lead to a lesser net balance of satisfaction. But this restriction is largely formal, and in the absence of fairly detailed knowledge of the circumstances, it does not give much indication of what these desires and propensities are. This is not by itself an objection to utilitarianism. It is simply a feature of utilitarian doctrine that it relies very heavily upon the natural facts and contingencies of human life in determining what forms of moral character are to be encouraged in a just society. The moral ideal of justice as fairness is more deeply embedded in the first principles of the ethical theory. This is characteristic of natural rights views, the contractarian tradition, in comparison with the theory of utility. In setting forth these contrasts between justice as fairness and utilitarianism, I have had in mind only the classical doctrine. This is the view of Bentham and Sidgwick and of the utilitarian economists Edgeworth and Pigou. The kind of utilitarianism espoused by Hume would not serve my purpose. Indeed, it is not strictly speaking utilitarian. In his well-known arguments against Locke's contract theory, for example, Hume maintains that the principles of fidelity and allegiance both have the same foundation in utility, and therefore that nothing is gained by basing political obligation on an original contract. Locke's doctrine represents for Hume an unnecessary shuffle. One might as well appeal directly to utility. But all Hume seems to mean by utility is the general interests and necessities of society. The principles of fidelity and allegiance derive from utility in the sense that the maintenance of the social order is impossible unless these principles are generally respected. But then, Hume assumes that each man stands to gain, as judged by his long-term advantage, when law and government conform to the precepts founded on utility. No mention is made of the gains of some outweighing the disadvantages of others. For Hume, then, utility seems to be identical with some form of the common good. Institutions satisfy its demands when they are in everyone's interest, at least in the long run. Now, if this interpretation of Hume is correct, there is offhand no conflict with the priority of justice and no incompatibility with Locke's contract doctrine. For the role of equal rights in Locke is precisely to ensure that the only permissible departures from the state of nature are those which respect these rights and serve the common interest. It is clear that all the transformations from the state of nature which Locke approves of satisfy this condition, and are such that rational men, concerned to advance their ends, could consent to them in a state of equality. Hume nowhere disputes the propriety of these constraints. His critique of Locke's contract doctrine never denies, or even seems to recognize, its fundamental contention. The merit of the classical view, as formulated by Bentham and Edgeworth, Bentham, Edgeworth, and Sidgwick, is that it clearly recognizes what is at stake, namely the relative priority of the principles of justice and of the rights derived from these principles. The question is whether the imposition of disadvantages on a few can be outweighed by a greater sum of advantages enjoyed by others, or whether the weight of justice requires an equal liberty for all and permits only those economic and social inequalities which are in each person's interests. Implicit in the contrast between classical utilitarianism and justice as fairness is a difference in the underlying conceptions of society. In the one, we think of a well-ordered society as a scheme of cooperation for reciprocal advantage regulated by principles which persons would choose in an initial situation that is fair. In the other, as the efficient administration of social resources to maximize the satisfaction of the system of desire constructed by the impartial spectator from the many individual systems of desires accepted as given. The comparison with classical utilitarianism in its more natural derivation brings out this contrast. And that has been Matt Reed's books. Tune in next time for the next section, Intuitionism, and other things that will follow it. Yep. Bye.